What's going on, YouTube? Today we're going to talk about the notary certificate of default method, which is a very effective method. Make sure you guys like, subscribe, comment, and make sure when you subscribe you hit that bell to receive notifications on any new videos I upload and for all new updates. If you're not a part of the Hellraiser Legacy, the link is below inside the video to become part of the private community. Alright, so the notary certificate of default method. The notary protest method, or NPM, is an administrative technique based on the Uniform Commercial Code, or UCC, that involves the presentment of strictly commercial negotiable instruments to financial institutions such as banks, creditors, mortgage companies, and etc. Commercial negotiable instruments include things such as promissory notes, bills of exchange, bonds, and checks. The NPM method provides an administrative, non-judicial method that uses a notary public to complete or to create certified court admissible evidence that the financial institution has dishonored a financial instrument that you want them to accept. Statutes exist on the law books in many states documenting and regulating how and under what circumstances this method may be used in several states. If you go over the internet and search for the phrase notarial protest, you will find that this is a procedure used all over the world. In the tax honesty movement, the most commonplace situation you will have to deal with this is the stubborn, overworked, and incompetent government or bureaucrat or agency that either ignores or refuses to respond to your correspondence related to a non-liability. So this is an important procedure to use anytime we're disputing a certain situation. We send out our disputes or our counter offers or our or our notices of non-liability, so forth, so forth. Now, this is the secret weapon that we use in return if the original methods of or administrative process that we're trying to conduct fails because the agency is trying to ignore the notice. Now, the notary presentment method has been adopted and modified for use in such situations against the IRS and your state taxing authorities in a revised process we now call the notary certificate of default method. But warning, we caution that you should be very careful not to mistakenly call this modified administrative procedure. Okay, so we got to make sure that we do not mistakenly call this modified administrative procedure the notary protest method, because it is not related to the commercial negotiable instruments, and because if you do, you could actually cause the state to pull the license on the notary you are using. Very important. So state laws regulating notary publics are very specific, and notary can get in trouble with the state for improperly executing the notary protest method documented in their states or documented inside of their statutes. When you also consider that you may attempt to use this notary protest method against the state taxing authorities, and these are the same authorities who license notaries. So keep that in mind. Then you want to keep your notary public's whistle very clean, so they aren't the object of the state retribution for any reason. Therefore, be careful in the language you use to describe what you are doing by calling it the notary protest method. Several individuals claim a 100% success rate against state taxing authorities and the IRS using the notary certificate of default method, and we therefore encourage its use. The reason it works is because it is the same technique that is used by yours truly, the fucking IRS. Now, there are several approaches similar to this, which are called the nihil dicit judgment. I'm not sure about that pronunciation, and also the default judgment. I'm pretty sure by now we should be aware and familiar with the whole default judgment. For those that are not familiar with the whole default judgment process and procedures, is basically this: if we decide to dispute a certain issue with a particular agency and we want to use the judgment by default method, we need to understand that that particular method in particularly could take 3, 4, maybe even 5 rounds before you can completely get to a point of success. Because let's say you send off a first notice. The first notice is either declaring your status or your standing, or making whatever allegations against whatever debt that you're trying to dispute. You'll send them a notice giving them a certain deadline to respond to the notice. It could be 10 days, 15 days, 30 days, or whatever. Each process has its different deadline. So after this, let's say after the 15 days or 30 days you gave them a notice, you didn't get a response like you requested. Then you send them. You have to make sure you send out round two. Round two may also give them another 30 days or 15 days or 10 days. They don't respond to that. Now it's a third notice. Just the same principles and same ways, basically how they deal with us. Because we get a bill or a debt in the mail from whatever company or agency, they're going to send us a first notice. They're going to send us a second notice with a nice pretty red stamp. Then they're going to send us a third notice. Then they're going to send us a final notice. And then after the final notice, we'll notice the last presentment or offer. It says final notice and judgment of default determination. So that notice of judgment of default determination is basically saying that, well, we're gonna judge you. You're gonna be charged in default to this determination, because for failure to respond. So failure to respond automatically puts you in a mind frame, or puts the creditor in the mind frame of saying like, hey, since you didn't respond, you're damn near, your silence is pretty much admitting to the debt, or admitting guilt. So we always have to respond by way of some form of presentment or counter presentment or offer when we're dealing with with these creditors or debt collectors. Now, the approach is more effective within the administrative realm, but it is also effective in a litigation environment as well when properly used following a court judgment. The basics of the approach in the Bible and common law. Jesus said in the Bible in Matthew 5:25 the following: agree with the adversary quickly while you are on the way with him, lest your adversary deliver you to the judge hand you over to the officer, and you be thrown in prison. In Matthew 5:25. When Jesus said the above to agree with your adversary, he didn't necessarily mean unconditionally. He didn't necessarily mean unconditionally agree with them. You can always conditionally agree with the person you have an issue with. Just like another administrative method is the conditional acceptance method, where I'll conditionally accept your offer if you can prove such and such, such and such. Could be jurisdiction. That's what we use a lot of times, claiming jurisdiction, that you have the jurisdiction to even accuse me of such, or to ask me of such. Now, when you make a conditional agreement, then you in effect have honored their request, but imposed the conditions to your performance by their request. If they respond by saying that they don't meet your conditions, then they have defaulted and dishonored your presentment, and you are the legal entity or entitled. You are legally entitled in the court of law to a default judgment or summary judgment in your favor and against them. To further explain this technique, how this technique works, please visit the Uniform Commercial Code. If a person presents a final claim or presents a financial claim against you under commercial law, then you have exactly 4 options for responding as followed: result of your action. Number one, honor. Your response, perform or provide what is demanded. Obligation, none. This is obligation on claimant to get his claim satisfied. Number two, honor. Conditional acceptance. Must perform under the conditions you set. Remember, that's key word, you set. See, the first one is the traditional method. Pretty much, if an agency or creditor sends you an offer or debt or obligation to pay, and you respond by performing or providing what they demanded, which is the money, along with whatever type of validation that they're requesting on your behalf, including the money, then okay, your obligation will be none because you pretty much you obligated yourself to the debt. So it's like it's over with. So now number two, the conditional acceptance that I just spoke on before. Now it must perform, or they must perform, under the conditions that you set in order to have a claim against you. And if the claimant won't, people that claim that you owe them, then they have dishonored your offer and defaulted, and must also surrender the right to their claim against you, which makes this an important strategy and administrative remedy. Number three, dishonor. Say you won't perform and raise a legal issue. Since you have defaulted and not disputed the base for their claim, then the claimant can get a court judgment against you for the amount demanded. So that means, okay, you agree that you owe the debt, or you didn't disagree by not responding. You allow the debt to accumulate and go over the timeline that it should have gone in. So now they say, okay, but this person is not gonna. We've been trying to recoup the money from the individual or from the debtor. They're not giving it to us. So their last tactic and strategy is to sell it. Basically, sell the matter or case to the court system, in which now everybody gets paid. So now they get the legal right of way to levy or lien your property or levy your income. Number four is dishonor as well. Remain silent. Remember, I told you before, you do not have a right to remain silent. At least not the majority of the time. You always, because remember, every time they send you a new presentment in the mail, it's a new offer, and you have to respond to that new offer. That doesn't mean you have to accept a new offer. A simple response could be cease and desist. Especially after you already addressed the matter by a certain administrative process. So now you demand that they cease and desist regarding this matter. So since you have defaulted and not disputed the basis for their claim, then they can get a court judgment against you for the amount demanded. That's again. So the same outcome when you fall in dishonor. It's a pretty long one. Let's do a little bit more. The key to making this technique work is to make the counterclaim or the conditions of the acceptance reasonable and lawful in the opinion of a judge or jury. The more conditions you place upon your acceptance, the more difficult it becomes for the claimant to comply, or therefore the less likely that it is that he will comply, and thereby make it necessary for you to perform in accordance with his demands. That means make your demands or counter demands or conditional acceptance of the demand that they impose upon you plain and simple, straight to the point, sticking to the facts and sticking to the law. So when applying this method to the IRS, all you're waiting is verification that you owe the debt, and then they say you and the debt they say you owe. Also, that they have lawful authority to collect the alleged debt and institute enforcement actions. Skip that. Now, several people and organizations have been using the notary certificate of default method. Miss Victoria Joy from San Diego, California, is one of them. She held a seminar in 2002 at the American Rights Litigators. Here goes the address on the Uniform Commercial Code and notary protest. Now, the ARL had her to do a seminar for them because she claimed to have a 100% success rate in court using her method of using the UCC and a notary protest. Now, October 2001, was when she started the process. Unfortunately, Ms. Joy's processes aren't documented because Ms. Joy and the ARL signed a non-disclosure agreement that limits what they can say. What they can sell or talk about. The notary certificate default method has a way of almost forcing the IRS or any government agency or even a private individual to dishonor you in their interactions with you. It's very important. This is done through a sequence of notarized correspondences between you and your opponent. Very important. It's a process, a number of sequences, which is akin to getting an administrative judgment against somebody. Same thing. The person granting the administrative judgment is the notary. Very important to understand the notary's position and power if utilized. The person granting the administrative judgment is the notary, who is supervising and monitoring and enforcing your interactions with the third party that you are corresponding with. They provide legal proof that you sent the conditional acceptance to the third party and proof that there was no response, because you need that. The no response is your victory. Okay, since they are notaries, the notaries are officers of the court. Officers of the court, then the officer of the court certifies with the notarized affidavit provided to you that you sent the conditional acceptance to the claimant and that there was either no response or a dishonor of your offer. The notary is identified in the correspondence and as the person or as the proper person for the claimant to respond to. Okay, proper person is very important. Okay, we need to research proper persona or persona. Now, the notary then awaits the response of the claimant, and when they refuse to respond, then a notarized affidavit from the notary is provided to you, indicating that indicating they defaulting and granting administrative law against the claimant that you can take into court to get a summary or default judgment against them. Very important. Let me go over that one more time. So once this presentment is issued correctly, the notary then awaits the response of the claimant. So the notary is gonna wait to get the response from the claimant, the person, governmental agency, or all the above that has a claim against you. They're waiting for the response, and your correspondence as the proper person for the claimant to respond to. The notary awaits the response of the claimant when they refuse to respond. Then a notarized affidavit from the notary is provided to you. A notarized affidavit from the notary is provided to you, indicating they defaulting or the defaulting and granting an administrative law judgment against the claimant that you can take in court of law to get a summary of default judgment against the claimant. Case dismissed, man. So the notary certificate of default provides a very good way to keeping your dealings with the IRS and your state taxing authorities at the administrative level, and prevents them from needing to escalate to the court level for resolution. Whenever the IRS disagrees with our position on something, we are supposed to be able to get an administrative law judge review, but it never happens. The NCD method is an administrative process done by a notary that one can use to get a remedy to a problem administratively. Notaries are officers of the court, and as such, they have much power in that position, although most notaries don't realize that. They don't. Now, let me see what we're going to go over. Burden of proof that respond. Well done. All right, let me read this one. By providing the proof of claim required exhaustive, you overwhelm the IRS by requiring them to produce so many things to meet the burden of proof that there is just no way they will ever respond. In that way, you can practically force the IRS or others to dishonor your conditional acceptance in their transactions or commerce with you. Okay, where does the NCD method come into play as far as the IRS agents are concerned? Well, anytime the IRS agent contacts you, it's always for one or two reasons. They will either be asking for a performance if they are an examination agent, or they asking for money if they are a collection agent. So when they contact you, that means they have made a presumption that they have a claim on you. When you conditionally accept the agent's claim upon proof of claim that is legitimate, they must either come up with the proof or dishonor it. If they dishonor it, then you send them a notarized notice of default and opportunity to cure letter notifying them that they have defaulted and thereby agreed to your position, and you state in the notice that you are giving them one more opportunity to cure the default before the judgment is final and is not appealable. If they refuse to respond to the notice of default, then you send them a notarized certificate of default via certified mail. You retain the certified mail receipt for all correspondence you send and a notary signature on all documents you send, allow the documents to be directly admissible as evidence in a court of law. Period. Case dismissed. Now, I'm going to skip past that. They also talk about the UCC and how to use the notary certificate of default in the Cracking the Code 3rd edition. Very powerful book, which all of you that are members of the Hellraiser Legacy should have already downloaded and cracked open by now. Check that out. Heavy. Now, I'm not reading this from the Cracking the Code book right now. It's another resource that is also available to you guys that are part of the Hellraiser Legacy if you have dug deep enough to find it. If you guys would like to know exactly where I'm looking at this this document at, I will upload it on the main wall on the site. Now, how to craft good conditions / questions. In crafting your conditions for proof of the government claim, try to do the following from the guidelines. Okay. All right, so this is an example of pretty much what to do and what not to do as far as your communication or language with dealing with these officials or agencies. Okay, so example number 1 is I am not a U.S. citizen. Incorrect. The correct way will be I am not in receipt of evidence by the government demonstrating that I am a U.S. citizen. Okay? And I hope you guys understand the difference between those two statements. Because if you just say I am not a U.S. citizen, that leaves room for them to counter that statement against you. But instead you say, because in all actuality, they might have more evidence that you are a U.S. citizen, or consenting to be a U.S. citizen than you do. Then you have to deny your citizenship, which is the majority of us. All right. So instead, I am not in receipt of evidence by the government demonstrating that I am a U.S. citizen. Now, number two, you do not have legal authority to assess me. Okay? Really? Okay. How about I am not in receipt of any statute and corresponding implementing regulation that together authorize you to assess me with tax liability. I am not in receipt of the pocket commission or pocket commission serial number for the assessment officer showing that he has the authority to do an assessment. 3. You can't demand a tax return from me because I can't be compelled to incriminate myself in violation of the Fifth Amendment. Okay, that's not bad, but how about I am not in receipt of evidence from the government explaining how I can file a tax return without violating my Fifth Amendment right to not be compelled to self-incrimination. All right. Remember that if there are no disputes between you and the government over facts or evidence of proof, then judges have the discretion to deny you a jury trial because of all the issues are legal. Okay? All right, y'all. I'm gonna go ahead and close it up, man. If y'all wanna dig into this even further, make sure you guys join the hellraiserlegacy.com. The link is in the description. If you're already a member, uh, go ahead and hit me up, and I'll send you guys the direct link to this. But I'm gonna be uploading the link into the the link is gonna be on the main wall. Well, not the main wall actually, because the main wall is accessible to the public. So I'll find somewhere to put it at. But till next time, finna get on to the next video. Very exciting video. Peace out. Like, follow, share, subscribe, comment. Let me know what y'all think. Peace out.